last week, we were sitting, this week actually, we were sitting and giving out areas of jurisdiction to auctioneers. So it is the good leadership of these gentlemen and ladies you see here. Gentlemen and ladies look the way they look. Thank you. We are looking forward to this association. Before I come to my part of the program to give you the practice of an auctioneer, I just want to go off the cuff very briefly and say, and of course a lot of you have urged me to do this, so I will. The gentlemen and ladies in this hall yesterday and today, we've no doubt in anybody's hand, in anybody's mind, that it is the quality of leadership of the institution, the licensing board, that continues to drive the positive evolution of the auctioneer. Your Lordship, board members, have continued positively to interact with the auctioneer to the extent that the auctioneer continues to realize continued growth in their level of appreciation within various circumstances. The positive attributes of the speech yesterday by the Honourable Minister. The Honourable Minister said, and I quote, to your Lordship, that you are a friend. Give no doubt as to your qualities and leadership. Lordship, the auctioneer today is enjoying the fruit of that quality leadership. We have not had the collective opportunity as we have now today, which we all want to do. To stand up, ladies and gentlemen, please. Not the board. And a round of very serious applause. Thank His Lordship and the board for the amendment to the Act, to the rules, and most precisely to your remuneration. A lot of you have said, when can we ever thank? And I said, the best way we can do it is to thank these able gentlemen and ladies and your Lordship for the amendments to our Act, to our rules. The amendments to the auctioneer's rules that continues to make our work a lot easier and the enhancement of our fees. We will not forget at the last seminar in August 2008, at this very day, at your behest, the Lordship, and just having been appointed chairman to the board, you led us in creating the auctioneer's code of conduct, which document one speaker did mention yesterday that we did need to have. But I am sure you did not know that your invaluable input at the last seminar, which was later ratified at our AGM in Mombasa, which you did attend, thank you. General body, plenary here, and the final presentment of the Code of Conduct and amendment. Your Lordship, members of the board, my fellow colleagues, the need for one strong association could not have been stressed any better than the Honourable Minister did yesterday, and the speakers that followed. Today we expect the Honourable Attorney General, and I would wish to quote from his letter dated 22nd November 2007. I quote this letter by the Honourable Attorney General, saying, I appointed a task force to review all laws relating to auctioneers. The main aim of that was to professionalize auctioneers. Therefore, to have them under one body is very vital. That objective is to be achieved. Your Lordship disclosed the numerical strength of the National Association of Kenya Auctioneers, that I am very proud chairman yesterday. Our strength stands at 186 members, which makes it about 90% of the membership. I am proud of that, and I'm proud of you all. And our colleagues in Kensop stand at 26. Our NACA members will never forget the number of years that we have lost in continued wrangles witnessed in previous years today. Call for an association the call for one association would never have been at a better time. I'm sure my colleagues will agree with me that at the top of the list of the amendments we have forwarded to you, though that's this first amendment I haven't from, but I'm sure my colleagues will agree with me, that to enable the board to continue in the strength and spirit that it has, my Lord, this member body has requested that Section 3(1)(a) of the Act should read, there is established a board to be known as the Auctioneer Licensing Board, which will consist of, and we say, replace the word one person qualified for appointment, 2, a judge of the High Court of Authority. Your Lordship, I know my brothers would want that amendment to ensure that you remain as the Your Lordship, the challenge by the Honourable Minister for the Task Force at Your Lordship's vision to crystallize Section 8(1) of the Auctioneers Act, where the board becomes a functioning corporation, should be struck while the iron still works. We believe in your able leadership. We know Your Lordship very close to us. Thank you. I will now proceed to my presentation. Practice of an auctioneer. Yesterday, the evening, my colleague, Mr. Vitao, it started out by listing the duties of an auctioneer. I will similarly run through them very quickly. The auctioneer, 1, attaches for sale, movable or immovable property, execution of a court order pursuant to the provisions of the law. The auctioneer sells or offers for sale any movable or immovable property, any interest therein, an auction, or by any other mode of sale by court. 3, levies, auctioneer levies distress for rent or restrains under the provision of any written law. 4, the auctioneer carries out eviction under an order of court. And 5, the auctioneer possesses goods of any person pursuant to the provisions of any written law or contract. This person shall, for purposes of the Auctioneers Act, be deemed to carry business connection. The Auctioneer's Rules number 3(1) states that a Class A auctioneer shall hold a general auctioneering license and shall enable the holder to realize, charge securities, to possess and sell properties, but limited to specific provinces. I noted in the exam Thursday that a lot of our new colleagues whom you tutor made that error. Instead of writing district, the provinces, they wrote districts. So kindly, when you continue tutoring these young men and women who want to become auctioneers in the future, please advise them correctly. B. States that a Class B auctioneer shall hold a general auctioneering license which shall enable him to realize charge securities, possess and sell any property, throughout Kenya, execute court orders levied distress within specific districts. The difference between A and B is that B is confined to districts in the execution of court order, but not confined to provinces. You can repossess and realize securities throughout the country. Once the auctioneer is licensed, as you all know, lately, the process is rather rigorous. The auctioneer will have been expected, even during his internship with you, this tutor, to have been able to market himself to clients. Therefore, when he has his own office, upon receipt of any instruction, the auctioneer must first register, same in a register, confirming that the instructions issued to him fall under the previous mentioned category of instructions, whether attachment, warrants of attachment, or sale, or attachment before judgment, or of eviction, or letter of instructions. These must all conform to specific forms. Warrants of attachment must conform to the Civil Procedure Appendix D, Form number 7. If you look at the Civil Procedure Appendix D, Form number 7, you will see the same warrant of attachment that is normally issued to you. Warrants of sale must also conform to the Civil Procedure Appendix D, Form number 25. Orders for attachment before judgment must conform to the form Appendix E, Form number 25. A notification of sale must conform to Appendix D, Form number 27. Order for eviction, and that notification of sale are those properties which are sold through a decree. An order for eviction must clearly state the persons to whom it is directed to and with concise particulars. You're not supposed to just get an order that has been extracted by maybe the decree holder. You are supposed to get an order that directs you in person in particular. An order for attachment before judgment must also conform to Appendix E, Form number 5. And your letter of instruction to repossess from a licensed financial institution or an authorized hire purchase agent must conform to the second schedule of the Auctioneer's Rules, Sale Form 1. The letter of instructions to realize security must also conform to the second schedule of the Auctioneer's Rules, Sale Form 1. The letter of instruction of distress for rent or any other lawful distress must conform to the second schedule of the Auctioneer's Rules, Sale Form 1. These are the very basic authorities, the very basic documents that give us the authority to proceed as we are required to proceed. If you do not have any of these documents in the prescribed form that they are said they should, then surely you do not have an instruction. The other day I had somebody ask me why we are not given indemnity by lawyers. But if you are instructing party, you ensure that your instructing party follows the rules, then Sale Form 1 always indemnifies you in whatever instruction that you receive. The Act requires that you record all your instructions upon receipt in different registers, as this will help you in the ease of follow-up of the files in your operation. How does this help you in the ease of follow-up? I will explain at a later point. I will continue. An auctioneer class A or B will receive instructions to repossess from a recognized and licensed financial institution or hire purchase car dealer or hire purchase merchants whose clients have executed duly registered chartered mortgage, giving them the right to repossess the listed securities. Only listed securities. The instructing party will on instructions surely give you on the instructions Sale Form 1 show the whereabouts of the chattel, its description, identification, mark and number, whether it's a radio, motor vehicle, as long as it is a duly registered chattel. Chattel's mortgage. Then and only then will you have the authority to proceed to repossess the listed item. Yesterday, I believe that question came up from the gentleman on the corner. And further, our licensing board, the state, very deeply answer you. The auctioneer will be required to locate the loanee, his agent, and the listed items. Issue is proclamation itemizing the items he is required to process, state the condition, and then place a value on the items and leave information to the other person finds in possession of the said items. If the loanee does not redeem the retained items, then on the expiry of 7 days, and not 6, you've seen cases of that, you must seize the items and sell the same at the newly advertised. You're not allowed, it's very important, to return a repossessed item to the instructed party. On receipt of instructions to realize the security, the auctioneer will as usual register his instructions and perform his due diligence by confirming with his instructing principle that the property is truly charged. At times a bank may say your property is not charged and ask you to realize. This happens with smaller financial institutions. They will give you a security, and when you ask them, was it charged? You say, you are the worker deposit property. So you really need to confirm that it's charged, because if it is not charged, you will not be able to realize it. The statutory notice has been issued on the requisite 2 months expired. But of course, the notifications conform to Appendix D, that is, if it is a decree of the sales and execution of property, and sale from 1 in exercise of the charging power of sale. Upon confirmation that the instructions conform to the rules, issue a notification of sale, as in sale form 4. Sale form 4 may be what the number we have not put it up. Sale form 4 is amongst our rules 2009. Sale form 4 is a form that gives you notification of the rule of property. And it refers, and it refers mainly, this trust comes from Rule 15. Locate the property and serve the notification of sale on the owner or another member of the family, simultaneously giving in writing to the owner of the property 45 days within which to redeem his property. He is also required to take out a letter by registered post to complete this process. Take note, though, that in the event the owner is deceased, this question did come up in our exam. Very few of you got it, that when very few of our new entrants got it, that if the owner of the property is deceased, what do you do with the notification? Because some of you received the notifications with the deceased person name on it from the bank. All you do is just copy paste the notification of sale, take it to the family, you serve the family. There have been several rulings in the High Court that service is invalid. Take note that in the event the owner is deceased, you must serve the notification on the administrator of the deceased or his estate. If you can't trace the deceased administrator, then you have to go back to your instructed party. It's failure to do so, the notification is invalid. Do not even address this notice in the name of the deceased, but the administrator, as in the event you address the deceased, it needs to be in his own. The expiry of the 45 days notice, the redemption notice period, arrange to advertise the property for sale not earlier than 14 days of the first newspaper advertisement. The advertisement, of course, must contain time, date, time, place of sale, conditions of sale where it may be obtained, time for viewing the property to be sold. Noting, again, that the auction must be held after 10 a.m. before 6 p.m. Once a sale is advertised, it will of course be expected at the sale venue with a good time, probably an hour or a day in advance, continue marketing the property. The time comes for your auction, please read out your conditions of sale and have them with you and attached to your memorandum of sale. Once you have knocked down the property as sold, ensure that the requisite 25% is paid at the fall of the hammer, not the latest, but on the same day. Ensure that your purchaser signs the memorandum of sale some purchasers have reneged earlier agreed terms. Please ensure, as usual, that the sums paid to you according to your principles within 15 days of the stipulated period. When the auctioneer receives warrants of attachment and sale, as usual, confirmation of the documents received as conforming to what is in the statutes. The warrants are valid, and some of us have received fake warrants. Some of us execute invalid. Issue the requisite proclamation to notice itemizing the judgment debtor's goods as pointed out by the decree holder. Due diligence, of course, in the case of motor vehicles and other items will equally assist you safely through the process, giving the condition of the goods and placing a value on the itemized goods. Please note that to enable us to enforce Rule 14, it is always best to ensure that the judgment debtor only signs your proclamation. Failure, of course, to sign the same will require you to certify that the judgment debtor or his agent, stating his name, declined to sign the proclamation. On the expiry of the requisite 7 days when no payment is received, you will proceed to seize only the proclaimed items. Advertise the same for sale within 7 days from the date of removal, and arrange for sale not earlier than 7 days from the first newspaper advertisement, and not later than 14 days. What that rule principally tells you is that once you touch the goods, you should not advertise later than 7 days. You should not sell later, not later. The sale should be after 7 days, but not later than 14. So, in principle, you should not hold those goods for more than 31 days, so that you do not charge storage charges on 150 days, unless there is an order staying the process. In the case of livestock, the auctioneer will be required, after the expiry of the 7 days' notice and upon seizure, to give the owner of the seized animals, of course, at the proclamation stage, it is important, the qualities and the markings of the animals are placed. The animal, Frisian, Holstein, Jersey, Guernsey, the specifics will help you very, very much in the eventual process. Give to the owner of the seized animals a notice period of 72 hours after sale. That, you remember, was amended from our rules from 48 to 72. And I believe I've seen a lot of matters where we realize we sell those cattle immediately after attachment. And we sell those cattle within 48 months. That within should actually be a period of time, but now it is 72 hours. It should actually be a period within which the judgment debtor should be able to redeem his animal. So of course, after the 72 hours, then you can proceed with the sale. Of course, in the case of perishables, we all know what perishables are. No such notice is required. In the case of perishables, I don't think a cow would be considered as perishable like a tomato would be. So in the case of perishables, then you will be required to sell them on the spot. The auctioneer, in the case of perishables and livestock, proceed to sell them without advertising the same if he feels that adequate notice to the prospective bidders can be achieved by way of radio, television, handbills, posters, or other means of communication. It is important to sell attached goods at a place you will be able to fetch good value on the goods, such that if you can retain them in situ, without the judgment debtor or the lobby cutting them away, it would always be a better option. In situ and a better value would be a scenario like this hall. For all of you who are here early in the morning, if you walked into this hall, you would look at the microphones, you would look at the tablecloths, the tables, the chairs, extremely well arranged. If you were to call bidders here to bid for them here, as compared to when they are heaped, a heap up there, you definitely get a better sale value of these goods. Unfortunately, our judgment debtors do not conform to the school of thought that the goods must remain in place until you come and sell them in this house. So, unfortunately, we cannot give them the benefit of that value. But if it is possible, then it would always be best to definitely have better value to put those, leave those goods in the city and sell them there. On receipt of instructions of distress to rent, you as usual on receipt on receipt of instructions of distress to rent, you as usual will register your instructions and receipt of the property as pointed out by the landlord. But in some cases, due diligence will be required, and that due diligence will be, you will be smart in purchasing a map of the sale area, as the properties are normally identified by the LR numbers, and you will be able to place the property and reach the property on your own. You will, of course, proceed to the property and claim the items you're allowed to claim by law. But note that these are attachable items within the tenancy only, not go beyond the tenancy. The property is Sumo Block 3, Block 4, and you cross the line to Sumo Block 3/5 because you leave the goods on Sumo Block 3/5 along the tenant, you will consider your goods. In matters of distress to rent, you all know that the notice period is 14 days. Other civic authorities, KRA, have their modes of recovery by way of distress, which entails different notice periods. But distress for rent does require 14 days from expiry. Again, the goods can be sold on site, which will be a plus for the eventual reduction of cost of removal, and of course, in enhancing the value of the goods. You will advertise the attached goods not later than 7 days and sell not earlier than 7 in the first advertisement. As usual, the sale proceeds are a must to 15 days together with your statement of sale. Ensure that you keep your clients informed in every step of the process of recovery. This will assist you and your client in decision making if you get held up in the process. If you had goods you were selling and not able to sell them completely, the statement of sale must accompany the payment to the client and must specify that certain goods were not sold for the reason to buy. Once your client is in the loop or is aware of this situation, he may even assist you in the direction as to their eventual sale. It is therefore important at any stage of all processes like I mentioned about the possession of these goods. It is to always keep your client advised. The client must have a copy of your confirmation of possession, attachment, distress, property realization. All these processes are informed by that proclamation, and of course, in the realization of security itself on form will be adequate more information to your client. Please note that the values you place on seized items must be real values you have noted that you normally fetch at public auctions that you do normally conduct. I have noted an auctioneer who has placed a value of 100,000 on certain goods, and thereafter sell the goods valued at 100,000, valued by himself at 30,000. You have a lot of questions to answer in a situation like that, and I believe you won't get away with it. It's very important in such events that you do not realize the value of the sale, to write to all parties informing them of the high valuation placed, probably what would have happened to the goods that it is unable to fetch the value. After which, of course, with maybe an instructing party, there may be an adjustment of the value, and then you'll be able to probably realize the same at auction. This is a common occurrence on repossessed items by financial institutions, where valuers place high values on possessed chattels, which values banks normally vary, thus guiding you in its eventual
sale price. But in such instances where you're processing, it is important to place your value on your proclamation at the time of sale of the proclaimed items. Our values, of course, give or take 20%, fall closely to the first sale value, owing a lot also to your experience. In time, we believe we will all be able to have set standards and literature about us all on how to value goods for auction. But as it is, it's important to always consult your senior colleagues on how to reach a value and start. Remember, it is that period of internship that qualifies you as an auctioneer. And we believe during this process you learn the ropes of the profession by your continued inquiry as to how to do certain things, studying auctions with help and in warrants of attachment before judgment, I believe we hardly do execute these orders. But for those who do, initially, before the court book result was repealed, an attachment before judgment was precisely that. You were required to attach the goods specified thereon and hold them at the court's disposal until further orders of the court. The risks, of course, were a lot greater, especially to your costs as the applicant might use the case. But again, the question that I know arises now that we have to give notice is that, are you supposed to give notice? I believe not, because in the proceedings, the affairs normally show that the defendant may leave the jurisdiction of the court, hence the necessity of holding on to the items stated there as a surety. Evictions are normally orders of the court, where the court directs the successful applicant put in possession of the suit premises. Once such an order exists, it is your duty to advise your client who may bring you a copy of such an order. To advise his advocates of the client in person to file an application to enable the execution of the court's order. Just as an application for execution to the issue of warrant, you are equally required to file an application for the issue of eviction order. Once the application is filed, the court will issue you, the auctioneer, an order specifically directing you, James Josiah, trading as an auctioneer, to put the successful applicant in possession of the property. Please note that when the order says that A in possession of the property, you are not required to bring down the building. No. You are only required to put Mr. A on the property by removing Mr. B who was on the property. But if the order says demolish the structure to pursue then proceed as such. Do not be taken as an overzealous officer who was only told to put Mr. A on the property, but you continue to break down the property. The order did not say. You must obey any order to the letter of this country. Above all else that we have discussed as to the procedure in proclamation and seizure of goods, it is important that these goods are safely stored and insured. Ensure that in the event of any mishap and safely stored to ensure that upon sale it reach a realistic value as to its condition as it was in situ from the premises you attached it from. Some of our stores are very cramped and end up actually destroying attached items. As I said earlier, our debtors in Kenya do not conform to the school of thought of sale in situ, but if goods are actually sold in situ, the cost and storage will not be necessary as it is space. In Nairobi, I know space is approximately Kenya shillings 100 per square foot. It's extremely expensive. So to place goods as they were in his office to enable you to attain good values is also not possible. But it's important that we try and store these goods adequately. I've seen some of us fall into traps of our own making where one holds on and has been directed to release the goods unconditionally. And the same have accrued monumental storage costs. It is your fault for not having taken any precaution. Some of us see lengthy storage periods as a time to be. But at times the orders come in the opposite direction, hence the unconditional release required. Upon noting that the matter will take a while in court, Rule 8.2 of our Auctioneers rules will assist you in filing an application to determine who will pay the cost of storage in any eventuality. when eventually there are orders for release, the court will have traversed the same earlier and will be guided accordingly. I've seen some of you who don't sit in their offices aware that there's such an order, wondering what to do next. A lot of these matters, we are the architects of our own problems. It is important, whenever we proceed to proclaim, that short of taking the ID number of the person we meet at the premises, we go to proclaim. You must deal with the person with the utmost courtesy. This will enable you to do the interaction with the person you meet. This will enable you to get to know his name. In the relation to the judgment letter or the law, if of course the person is in the judgment letter or the law himself. Getting his name will actually assist you when you sign your certificate confirming that I certify that Geoffrey can either decline to sign the proclamation upon presentation. When your proclamation is signed by the JD or loanee or your certificate, and the proclamation is properly set out, as I mentioned earlier, in the event the judgment letter or the loanee removes or violates Rule 14, you can then proceed to court through the decree holder. With these documents as your evidence, as the goods are already attached and were in the court's jurisdiction, the court may assist you in directing that the judgment letter produce those goods, therefore easing your work considerably. It's that point of documentation that will assist you in effecting or giving these rules impetus. This will assist where the judgment letter moves his vehicle to another area of jurisdiction which is not yours, as upon properly executing a proclamation, he moves the vehicle from the jurisdiction, the court will assist you in seeing your proclamation. He, having executed the same, may assist you in directing the judgment letter produced. Rule 9, of course, a lot has been said on Rule 9. We have all talked about Rule 9. And Rule 9, yesterday Mr. Owino was here, and I have had the opportunity to hear what magistrates say as to Rule 9. It is important, and I believe even in our own applications in the region where we are, in our own applications we must be specific as to what we want. But remember the specifics hold in Rule 9A, which is very clear. In the event that he believes he may have to break, he may be subject to resistance or a breach of the peace. He cannot deviate from these three. But in a nutshell, these actually call the basic orders we see. And these orders are not that the police break. These orders are just that you believe you have to break. The police will only come as a supervisory body. Your registers are a very integral part of your office. Your registers will comprehensively assist you in the proper management of your work. Once you have listed all the columns of the register, that is, of course, date of issue, degree, parties, determinable dates, and so on and so forth. At the very end, please place a column noting remarks. The standard remarks will therefore be whether you have proclaimed, whether you have attached, or you sent a check, the holder has paid, or finally, among other remarks, which should assist you actually confirming that the process or that the work given to you by your client works out. Warrants are issued. The columns must be quite sizable to enable you to fit in your progress reports. So that once you open your register, you should be able to establish your shortcut. You open your register and you look down at the side of the marks. You find the ones in blank. And you update it. This will really help you in knowing your continued progress with your client. Because that is the document that you open every day. Because when you get instructions today, you must open it. You must enter that instruction. Quickly look back, you should be able to assist you in a meeting with the officers. as to how well you have done work. You had a colleague yesterday, Hoffman. I believe basically at the end of it all, he talked about image. Of course, that an organized mind is organized well. It is important to reflect and look at what you do critically and appreciate the authority vested in you by your license, and that you deal with matters forwarded to you with due diligence. Our brother Felix, the eyes of the judiciary, Felix noted this, that the authority vested in us is immense. We therefore should not abuse that authority. The eyes of the judiciary, you are the officer who assists the litigant in reaping the fruits of his judgment or litigation. The eyes of the financial institution, you are the officer vested with the authority to realize securities entrusted to banks and financial institutions by lawyers. These securities are people's homes, families' homes, that are entrusted to these financial institutions, which are finally entrusted to you to realize. You can imagine that authority. It is therefore important for you to note your importance in the continued development of this country. The diligent, honest, courteous, and efficient delivery of the service, where an investor can be assured of an efficient debt recovery system. As we grow in quality, I'm sure the number of debt collectors we will see in the yellow pages will continually diminish. The yellow pages, there are a lot of debt collectors. If you look at a lot of the adverts in the newspapers today, you see a lot of institutions asking for debt collectors. But lately, if you look at it a little bit more, you will note that the numbers are coming down. I remember a previous venue, I told one of you, those same debt collectors, a lot of them emanate from your offices. Let us wipe these people out. Let us retain the collection of these debts within the confines of the Act and the rules, and let us satisfy our clients so that the numbers in the yellow pages of debt collectors continuously diminishes. Do not water down your authority by the unfortunate intrigues we hear of, though we know a lot of those intrigues do not emanate from licensed auctioneers. We have proof that a lot of these intrigues we have read about have been done by people other than licensed auctioneers. But I still say this, we still don't. So the best thing we need to do is get rid of them, let's get them out of our system. Besides the continued education program, you enshrined in our code of conduct and our rules, the continued education program which the board, inclusive of this seminar, will start rolling out effectively next year. The number of seminars you require to attend to enable you to qualify your license. We believe a handbook will be out shortly. We have been working on a handbook. We believe that will be rolled out very shortly to enable you to refer point-to-point references that will help you in the process of execution. I believe this will take us much higher than guidance. I thank you all.